what should this I can do? Both are agreed, then I can't do anything. What is the matter? How long have you been in practice?
I have no idea.
How long have you been in practice? How long have you been an advocate?
Well, that 6 months.
6 months. Next time you come before me, I'll have to have the facts from you.
Okay.
Your name?
Sita Jo.
Mr. C. Talu. A prayer is made on behalf of Mr. A.O. Modi, Learned Counsel for the appellant, for the petitioner, for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the Learned Counsel for the respondents. Accordingly, registry to list those matters again after 2 weeks on a date to be fixed by it.
Much obliged.
I'll remember you. Next time you come, make a mention. I'll not permit until you tell me the facts.
May I please, my lord. My lord, I am very unfortunate to mention here. Coming over here, an emergency call me from the school.
Huh?
From telephonic call, an emergency situation arises from the school. So I have to go to there.
Yes,
So
yes,
I
which
want to
matter?
mention
Which matter?
item number 4 and 6, my lord. Maybe taken up on Monday. 4 and 6. Now
6
situation.
is only a matter pertaining to contractual dues.
Yes, my lord.
We'll issue notice there.
Yes, Chairman.
4, I'm permitting you to do it on Monday.
Yes, my lord.
You are Mr. N. Tage.
Taje.
Yes.
Yes.
Mr. N. Tage, Learned Counsel for the petitioner 4 submits that the matter be adjourned today on account of the fact that he has to leave the court. He has to leave the court for some personal matters. So prayer is not objected to by the Learned Counsel for the petition respondents. Registry to list this matter again.
Second June.
2/6/2025. Item number 6, Mr. Taje, when a matter comes, I'll issue notice. I'll record your name. You can leave.
All right, my lord. Most welcome.
Your Lordship, I'd like to mention unlisted item. There is
What
a
is it?
bail application.
Can I or should we go there? Clear.
That's the last matter.
How many?
3 bail
3.
application. Much obliged. It's the last matter.
You can have it tomorrow morning. Tomorrow?
Your Lordship,
AB or BA?
regular bail.
Regular bill.
Yes.
Notice jayega.
Obliged.
By victim is item 10, 11, and 12. Also here we have received affidavit in opposition. We need some time to file our reply.
They have filed there.
Yes.
You are for the petitioner.
Yes.
Mr. Kato is for the respondent.
Fine. No response. No objection.
Huh?
No objection.
Mr.
T.
K-
Gatso.
T.
T. Gatso.
T. Gatso, Learned Counsel, appearing for the petitioner, submits that the respondents have filed an affidavit in the matter, and accordingly he prays that he be given
3 weeks time.
3 weeks time to bring on record the rejoinder thereto on behalf of the petitioner. Prayer is not objected to by Mr. M. Kato, Learned Counsel, appearing for the respondents. So accordingly, after 3 weeks on a date to be fixed by 10, 11.
Your Honor, I beg to mention item number 8.
Item number?
8. Item
Eight.
number 8. I'm for private respondent number 3 and 4.
Where is the petitioner in person? You have informed him?
I have already informed to him.
You have informed him?
Yeah.
A prayer is made on behalf of the respondents,
On behalf
private
of
respondents. Respondents number?
respondent number 3 and 4.
A prayer is made on behalf of the respondent number 3 and 4 for an adjournment in the matter.
On behalf of the arts owner. Arts owner.
A prayer is made on behalf of Mr. R. Sona, Learned Counsel, appearing for the respondent number 3 and 4 for an adjournment in the matter
3 weeks.
on account of personal inconvenience. Full stop. It is submitted to the bar that the prayer is so made with the consent of the petitioner in person. Full stop. Accordingly, the registry to list this matters after 3 weeks. Registry to list this matter again on. That's कितना तारीख है? 28.
29.
on 26/2025. The learned counsel for the respondent shall inform the petitioner in person of the next date fixed in the matter. Right? No, you inform the petitioner in person. That matter is fixed on 26/2025. Okay? 20/06/2020. 2020.
Oh, 20. Much obliged.
Your name?
N. Ranka.
Heard Mr. N. Manka, learned counsel for the petitioner, and also Mr. D. Loli, learned public prosecutor appearing for the state respondent. So issue notice. Call for the scan copy of the case diary. Charge sheet has not been filed.
File. Your
File.
Honor. Yes.
Call for the registry to requisition a scan copy of the trial court records of the charge sheet stated to filed in the matter. Filed in the matter. Full stop. Petitioner to take steps for service of notice upon the respondent number 2 through the jurisdictional police station, routing the same through the office of the public prosecutor, Government of Arunachal Pradesh, Itanagar, Guwahati High Court, Itanagar bench. Also, steps within 2 days from today, 2 working days from today. Registry to list this matter again after
2 weeks.
No, Your Honor, 1 week.
no, you'll have to take steps 2 weeks.
Much obliged.
Where is that case that has been now registered against you?
Well, I have no information about registration.
that-
My lord, there is a recent judgment of the Honorable Apex Court, my lord.
Hmm.
Because my lord, what in GST matters, my lord.
Yes, what is that matter? What is the registration, the case number? A notice has been issued to him.
Malat-
What happened thereafter?
Malat,
You
no,
have to register a case.
yes, Malat, exactly, Malat.
My lord, what
Let me
happened,
take
my-
instruction, Malat.
They have been constantly, they have been threatening us, my lord. They will take their coercive action, my lord.
The coercive action in connection with what? They can't take a coercive action only on the basis of a notice.
My lordship, what happened? Section
132,
132(5) is the offense non-bailable, my lord.
Oh.
If the amount is above 5 crores.
5 crores.
In this case, the amount is above 5 crores.
So
If
you,
it is-
that is there.
That is the.
But where is that prosecution instituted against you?
My lord, that is, my lord, they are not communicating anything. They are threatening us. That's why, my lord, I have made application to allow me to deposit the remaining amount in installments because my,
That is the different thing.
yes, my
altogether.
lord.
That is nothing to, for us to.
My lord, a coordinate bench is also entertained the petition orders, my lord. On the basis of someone also, my lord, the interim bail was granted, my lord.
That is different.
In GST matter only, my lord. Following, my lord, this Radhika Agarwal case.
Has a notice under section 69 come to you?
No, my lord.
Then
But Lordship will see section 69 does not prescribe for issuing notice, my lord. It simply says power to arrest, my lord. Section 70 says about issuance of summon, my lord.
Mr. M. Khatok, learned counsel for the petitioner, shall complete his instructions in the matter and apprise this court as to whether proceedings have been initiated against the petitioner for his default in paying the GST dues. Also, registry to list this matter again on Monday. You come online.
My lord, just till then some protection because I have appealed, that's why I have come, otherwise I would not have come, my lord. The reason
I
of,
know that. We'll see.
not,
We'll see what we can do for you.
till no
And,
coercive action, my lord, because Lordship will see there are two,
Coercive action,
Lord,
that are
civil
those
suit-
orders we are
no,
not.
Lordship will see there are two petitioners, my lord. Petitioner number 1 is the owner, petitioner number 2 is his husband, my lord. He has no connection with the business, my lord. That's why I must, some protection, my lord, till Monday, my lord. I have application, otherwise I would not have, I have made a statement in paragraph 7 and 9, my lord, that they are constantly creating pressure. Lordship will see paragraph 7, my lord.
One more day. We'll have it tomorrow.
My lord.
Can you take the instruction tomorrow?
Tomorrow, Malat.
Tomorrow. You
Then-
come online. tomorrow.
My
Tomorrow
lord.
first thing.
As of now, we don't know. What
What is it? You get your instructions tomorrow. Kal लगा दीजिए इसको अभी भेज दो. कल के लिए.
My lord.
Tomorrow.
My lord.
Jayalalitha's case, I'm just worried that you cannot pass a blanket order.
But when Radhika Agarwal GST matters, court has
Mr. Mujumdar was supposed to come online. What happened?
Yes, madam, I'm there.
Okay.
I'm there before Lordship, and we have filed the
Yes.
affidavit.
Mr. Sabin, what is
Madam-
your stand?
Lordship,
What?
I filed one affidavit, not
Hmm.
affidavit, on that particular point only.
Hmm.
Kindly take up my loss affidavit.
I have also filed my affidavit. I'll respond to my learned friends.
We have seen it, Mr. We have seen it, Mr.
My-
Mujumdar.
I have annexed the lordship
My-
instruction issued by the lordship Central Board of
Hmm.
Indirect Taxes and Custom,
Hmm.
just the Ministry of Finance, Central
Hmm.
Government.
Hmm.
Lordship, can you turn to page lordship? This is pertaining to 299 and relevant is at page lordship 303,
What is that serial number, para number?
7 lordship.
This is 323, page number 323.
Here
It
in
helps
my
me.
lordship,
No, there is some correction made. Such registered person would be requested to furnish form GST 3B for each quarter on or before 22 or 24 of the month succeeding month. So.
That is what I'm
in
saying, my lord.
Arunachal Pradesh, it is 24.
lordship.
Yes.
So what I'm pointing out, lordship, the from 1st April, lordship.
Need not be, he has, when the period is given till.
When
24,
lordship, I have asked for the updated GST return, lordship.
updated would be.
It's not the case that he could not have, lordship. It's not the case that he could not have. He could have, but he did not, lordship.
No. That is
And
not
he-
right.
Tell me one thing, he had given you the last quarter.
October to December.
Furnished. October to December,
Yes.
January to April,
Yes.
he can file till 24th.
He can find it.
But the problem is that when the rules say, when the procedure says that till 24th,
Yes.
you can ask for that as a clarification. You could have asked him, okay, give us this, what you have filed after 24th also give us. But strictly speaking on the, where is your condition? Come to the condition.
Page 36 of the petition, madam.
What is this NIC tender stipulation?
Okay.
Mr. Majumdar, what is this NIC tender stipulation in finding place in G? 15G?
My lord, frankly speaking, I also I don't have idea about NIC tender stipulation. But then only one thing I would like to suggest, my lord, page 323, which my learned friend has read, says that I can file the GST return for the first quarter only on 24th, not before that. My lord, NIC is National Informatics Center. National Informatics Center, my lord, NIC stands for.
No, what is that National Informatics tender stipulation?
My lord, NIC has actually developed e-procurement software solution, namely GEPANIC, my lord, for
His
tender
financial
matters.
bid was not open.
For
Yes. On
No.
in technical bid, he has been rejected, lordship.
What is the work involved, construction and improvement of some, how fast can you get the service of notice upon the private respondent affected?
Dusty, my lord, we can, my lord, Dusty we can do, my lord.
6 and 7.
My lord.
Work is been allotted to whom?
Not yet allotted, my
Not
lord.
yet allotted.
We-
It has
According
been
to my
opened,
instruction, my lord,
Open.
financial bid has not been opened.
lordship. No, it has been open.
Open.
I haven't told that. it's
Okay, heard Mr. D. Majumdar, Learned Senior Counsel, assisted by Mr.
Takar
P.
Baga.
Bora, my lord.
T. Baga, Learned
Yes.
Counsel appearing for the petitioner. Also, Mr. S. Topping, Senior Government Advocate, appears for the state respondents. Also, the petitioner has, by way of instituting the present proceeding, presented a grievance with regard to the decision of the bid evaluation committee in holding his bid to be non-responsive on the ground that the petitioner had not submitted his up-to-date GST return. Oh, sorry.
My lord.
It is submitted by Mr. Muzumdar that the petitioner firm has been submitting its GST returns quarterly, and accordingly, the said returns were to be so submitted on with effect from
24th of the succeeding month, my lord,
24/4/2025.
of April. Yes, ma'am.
Right? April,
My lord.
24/4/2025. Oh, so he submits
Yes,
that
ma'am.
the present tender was issued on
10/4, my lord. 25.
10/4/2024.
Mm.
And the
25
last date for submission of tenders were 16/4/2025. Accordingly, it is submitted by the learned counsel, senior counsel, that the petitioner had submitted the returns so submitted by him till the last quarter, which according to him was the quarter starting from October 2024 to December 2024. So the said position is disputed by Mr. S. Tapin, who submits that when the tender conditions have stipulated submission of the up-to-date returns, the petitioner firm was required to submit the returns till March 2025. Accordingly, he submits that the bid evaluation committee had not committed any error in rejecting, in holding the bid of the petitioner to be non-responsive. So, the rival contentions have been considered by this court, and this court is of the considered view that the same would require a further examination. So, accordingly, issue notice returnable when? Mr. Patil, when? Early date.
I lost it for June 5.
5.
Lost it.
We'll have it on 9 or
9th,
4 or 9.
yes.
4
Let it be-
or 9, when?
Let it be
4 or
9th,
9,
my lord.
when?
Otherwise lost it.
9th, my lord.
4 lost it.
4,
9th,
Nine.
no, 9th will be
Okay,
convenient
nine.
for me.
9 lost it.
9, 6,
9
Nine.
I'll be having some difficulty.
10,
Otherwise, it can
10.
be on 11 lost it.
Then 11,
6,
11, ma'am.
2025. 11/6/2025. Petitioner to take steps for service of notice upon the private respondents number 6 and 7. For issue notice, Mr. Tapin accepts notice on behalf of the respondent number 1, 2, 3, 4, and 5. No formal notice be issued, is required to be issued. However, extra copies of the petition, requisite copies of the petition be furnished to Mr. Tapin, learned senior government advocate. Full stop. Petitioner to take steps for service of notice upon respondent number 6 and 7 by way of registered, by way of dusty mode. Steps be notice be served upon the respondent number 6 and 7 on or before 5/6/2024. Petitioner to file an affidavit after effecting service of notice upon respondent number 6 and 7 on or before 9/6/2025. Full stop. Considering the issue arising in the matter, it is directed that till the next date of listing, while the respondents may process with the tender, however, no work order be allotted to the selected bidder till 11/6/2025. Further directions as would be required in the matter would be so passed upon the appearance of the respondents number 6 and 7 in the matter.
Lost it, may say lost it without leave of this court.
Fine, same thing.
Same
You
thing,
have
ma'am.
to file an application again.
Lost it here is very lost it, very on pace. It's he could have lost it.
No,
He
no,
could have,
my-
but
Mr.
it's
Tapin,
not that he could
Mr.
not have lost it.
Tapin, Mr. Tapin, that
Lost.
is the only area he could have.
Lost it.
If he did not, whether it will have a penal effect on him. That's the only thing we'll have to affect. He has also filed an affidavit. Therein also it is said that 24th. So something which
My
he
lord-
is not required to do, you cannot make it a mandatory condition. That's the only query of this court. You satisfy, we'll hear it.
The condition.
You
My
rely on Silpi and all. Everything is there with you. But for that,
That-
let us have a
That
proper
can be
hearing.
placed by now also. Lord.
Let us have a proper hearing. Yes,
My
Mr.
lord, my lord, just lordshiply, excuse me, just 1 minute.
Ah.
My learned friend's document itself says that 24th is the first date. There is a due date. Before that, I cannot.
This has honor reported.
Mr. Mojumdar, Mr. Tapin is on a different footing altogether. He says that if you were so desirous, you should have been prompt. Because you
No, my
can
lord.
submit this even before 24th. That's what he says. Because the word used is on or before 22 and 24 as applied in the state concern.
And the last date for submission of bid was 16th.
Fine.
Last date.
You could have done it if you could have populated your thing because everything was concluded in March 31st. You
No, my
had
lord.
16
Due-
days with you.
My lord,
That is the only
sub-
thing we will examine, Mr. Mojumdar. That
my
is
lord,
the
yes,
only thing
yes,
we will
yes.
examine.
My lord, my submission will be subject to lordship consideration. The first day on which I can submit is 24th for state of Arunachal Pradesh. Before that, I cannot.
That we will take. If that be the position, we'll direct for your bid to be considered. Otherwise,
Right.
by following the judgments of the Supreme Court that the author is the best judge of its conditions, we will dismiss your risk.
Lordship,
Silpi.
GST of the other bidders, Lordship. It was filed on Lordship 14, 15, Lordship.
Let the private respondent also come. Let one more advocate also
Why
come.
I'm
You will see.
objecting? Why I'm objecting? Because the development works, Lordship. Just
I know. That's why I'm not saying because you have not gone ahead with the work.
Lordship.
That's why I'm saying till 11 don't do. You do whatever is to be done. Don't issue the work.
Lordship.
On 11 we'll see.
Obliged, lordship.
May I, Lordship? Lordship, this matter is also pertaining to the contractual dues. Lordship.
But here there is a catch that 15 to 24 notification. Why were you waiting for 1 year?
Lordship,
You were waiting for 1 year.
Lordship, in the month of January only, I was made aware of.
You come to page 38. Explain that to me. Second paragraph.
38, Lordship.
Second paragraph.
Lordship,
This order is binding on me.
Lordship.
It may not be binding on you. It's binding on me.
Lordship, during that pendency, Lordship, the petitioner had made an endeavor to approach.
What
the-
endeavor? Where is the fresh cause of action?
Lordship, personally, he appeared before the respondent, but.
No. Where is the cause of action? Nothing. There has to be something, either a rejection or delay. This is 7-5. You are back again on after 20 days. Why? This order, see
Yes, Lordship.
your submission.
Yes, Lordship.
I'm not entertaining this.
Lordship, otherwise I may be able to withdraw the petition, if any.
Why did you file it at the first place? If there is, because otherwise there was no issue. I could have issued a notice in this matter.
Yes, Lordship.
But this order is standing in my way.
Lordship, I may be allowed to approach this honorable.
You have
if-
already there.
Yes, if any.
Mr. Your name?
Please, I can.
Mr. D. Saikia, learned counsel, heard Mr. D. Saikia, learned counsel for the petitioner, and Mr. B. Pincha, learned standing counsel, Rural Development Department. Ms. Bosa, you are appearing for respond number 3. Ms. R. Bosa, learned government advocate, appears for the state respondent. Full stop. After attempting to argue the matter at some length, Mr. Saikia, learned counsel for the petitioner, in view of the observations made by this court, why in the order dated 7/5/2025 passed in WPC number 17/2025 submits that he be permitted to withdraw the present writ petition and with liberty to refile the same if fresh cause of action arises. Also, prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter, accordingly, the writ petition stands dismissed on withdrawal with liberty as prayed for. Next time, without a cause of action, don't
Lordship.
come. This time it will be cost.
Lordship.
Was a similar matter pending before this court earlier involving the same parties?
No, at least, I'm not aware.
Oh, I had done it.
Lordship, I have instructions that charge sheet has been filed.
Rashid has been filed.
Yes.
Mr.
Lordship, I am for the petitioner, and I have objection since I have filed for setting aside of the FIR, passing of the FIR. So let me argue.
No,
Then
no,
also-
we'll get a scan copy of the. Scan copy has come.
Earlier order to pass to
scan
furnish
copy has
furnish
come.
copy today.
Where is the scan copy? Have you gone through this? Scan
No.
copy, have you?
No, Lordship. The charge sheet I have not received.
Lordship, here only we have to discuss about the FIR and the section 66E of IT Act 2000. Nothing is there in this case.
No, I can also look into the charge sheet.
Lordship,
Well, I can still exercise my right of
Lordship,
quashing.
Lordship,
I can always examine the charge sheet.
Lordship.
Let them also go through it once. The scan copy of the charge sheet of the lower court records have been received. And the same is kept along with this file, full stop, along with the case records, full stop. The learned counsel for the respondent submits that they be given an opportunity to peruse the same, full stop. The learned counsel for the parties are at liberty to peruse the scan copy of the so and so before the किसके पास रहता है फाइल before the नहीं रीडिंग सिस्टम उसका ऊपर में कौन रहता है before the deputy registrar judicial. You can approach the deputy registrar judicial. Before him, you can peruse it, make your notes, come back.
Lordship.
When? Registry to list this matter again on
Monday, Lordship,
Monday will not be. Monday, Tuesday will
or
not be.
Friday.
Next Friday. We'll have it on Monday, 9,
Ninth.
9/6.
Highly
Maybe this court would be a bit early to rise.
Lordship, then can it be on
9,
tomorrow, Lordship?
many matters.
Lordship. Otherwise, Monday, second,
Second, I'm told you, second, third, fourth, there are matters. This will take some time
Lordship.
because we'll have to interpret the provisions of the act.
Yes.
We'll have it on 9.
Lordship on
Ninth.
fifth, Lordship, because I am thinking of going out of session actually.
Okay, then let it be on 5th, 5, 6, huh? 5.
Oblige.
High level.
But Mr. N. Tage, learned counsel for the petitioner. Also, who is appearing? Also heard Madam Kanamliji. You have heard all the respondents
Yes, sir, Lordship, 1 to 4.
appearing for the respondents. Government advocate appearing for the respondents. So the petitioner has, by way of instituting the present proceeding, raised a grievance with regard to non-release of his pending LTS bills amounting to rupees 13,93, 13,250, rupees 13 crore 93 lakhs 13,250 bracket over only. So issue notice, Ms. So-and-so accepts notice on behalf of all the respondents. So service complete, no formal notice is required to be issued. However, learned counsel for the petitioner to furnish extra copies of the requisite extra copies of the petition to the learned government advocate. So steps within 2 days. So the learned registry to list this matter after 4 weeks. In the meantime, the respondent shall bring on record their stand by way of bring on record their stand by way of filing an affidavit.
Yes, sir, Lordship.
Well, the item number 13 and 14 is some similar nature case. I'll let this method be heard together.
Hearing.
My lord, this case is relating to,
Before you start off,
my lord,
parity of pay
Yes,
will not apply directly. You will have to demonstrate that you are doing the same nature of work.
yes, my lord.
Huh? I caution you that there is an affidavit on record wherein they have categorically stated that the work you are doing is not similar. Yes, Mr. Payme?
Yes.
That is,
You have not filed a rejoinder to that. You will, if
that
you
is
want
there.
to hear the matter, you are running a risk.
No, I'll take the risk, my lord.
You'll
No,
take risk.
No,
Huh? You'll
No.
take risk. Okay.
No.
Then please don't afterwards say
no,
that this court by following the affidavit has rejected your matter.
no matter,
Okay,
no matter.
then go ahead.
Because your lordship will pass the order on the basis of merit of the case. I believe,
But- but-
it's so.
No. But Mr. Counsel, I can also ignore when it's merits, I can also ignore the stand taken by the respondents in their affidavit. Very categorical that you are not doing the work of a grade 4 employee. You are only assisting while they are. You bring a rejoinder to this. I'll have this case on Tuesday. You file a rejoinder.
In that case, then I have
Ah.
a lot of reason.
But file it by Monday.
My lord, Monday, I will be
No,
not.
Monday. I'm here. I have read this brief. I can
My
pass the
lord,
order.
tomorrow,
I only,
just a second. My lord, tomorrow I am going to Guwahati for my personal treatment. So I may come back on Monday.
Monday, when you want to file that?
If not holiday, 6 or 7, any, either of the two.
The learned counsel for the petitioner submits that he be granted a week's time to bring on record a rejoinder on behalf of the petitioner. दोनों में separate मार दीजिएगा. Petitioner on behalf of the petitioners against the affidavit filed by the respondents. Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter again on 11/6/2025. The petitioner shall, in the meanwhile, before the next date of petitioners before the next date of listing shall invariably bring on record their rejoinder as prayed for.
All right, my-
Just get that, otherwise it is difficult.
all right. Thank you.
In the office note dated 28/5/2025, the trial court records have not the trial court records have not been received. Also, a registry to send a requisition for procuring for receiving for forwarding of the said trial court records by the registry to requisition the said trial court records and list this matter again after 2 weeks. Also,
My lord, kindly a fixed date, my lord. June 6th, if possible, my lord.
2 weeks, because that thing has not come, so they'll have to send a requisition. Bombdilla, rainy season, 2 weeks here, let it come.
Much obliged.
If it was UPI, I would have just get hold of those records here. Yes.
Lordships, it's a regular bail application, your lordships.
Hmm.
The petitioner, is behind the bar for last more than,
Lordship,
38
Lordship, and I had objected the bail application. Lordship, she is not cooperating, Lordship.
She will cooperate now. That will put conditions. Inside the judicial custody, she is of no use to you. You're not doing anything, Mr. Burua. hold it. You're not doing anything. You're not going there. Let her come out. She will not leave the jurisdiction of this court.
Yes.
Without leave.
Yes.
Huh? Right? And Mr. Counsel, this is not the money suit. This is an offense. You can't get your money recovered in this manner. She is inside the jail. Yes.
My lord, I already submitted my bail objection regarding the
We've seen
matter.
it.
I am highlighting some points, Your Honor. First of all, Your Honor, the FI lodged on the January 2025. Then after they arrested in their native place, in his
I'll
native place.
ensure that she does not leave here.
And second thing is that neither the
With further condition that any violation of the bail conditions, it will be like the prosecution will be entitled to file an application before the trial court for cancellation. I'll do that.
My lord, how arrest was made? After making an agreement for repayment, she remained absconded at Bihar. And after taking lots of trouble, she could be arrested by the Arunachal police. in case bail is granted, there is every possibility that she will not be able to, it will not be able to ensure that she will present in the court.
I'll say that there will be a security guarantor, plus she shall not leave the jurisdiction of the court, trial court without.
In that case, no problem, but
One, two, every week till the investigation is complete, she will report before the 15 days. Every 15 days, she will report before the IO.
right.
Anything more?
In between, what will happen, I don't know.
Then let
But-
that happen. That we can't know. We are only till today. Tomorrow, what
But-
happens? How
But
can
there
I
is
know?
always apprehension.
Let
She,
it
she
be.
may, she
But
may remain.
This is not a case wherein she further custodial interrogation is required. She'll cooperate. We'll do that. We'll do the needful. Right? And this is not a money suit. You can't get your money in this manner.
That is
For
true.
that, you file a money suit. Parallelly, that will also go ahead. That will also bind her down here.
My lord, that is also true. But my lord, how she remain at Bihar?
That is why she is behind the bars for such a long time.
She had 3 places.
When was she arrested?
22/4/2024.
1 month, 24,
22/4/2024. 25.
25. 1
Sorry,
month,
sorry.
enough. 1 month,
It is 1 month, my lord.
1 month.
But still, I have objection, my lord.
Will record your objections. Vehemently object. If I we'll pass it on the window.
Deeply.
Chamber.
Deeply.
Bail granted. But strict conditions along with the stipulation that any violation, it will be open for the trial court to, on an application made to cancel that. Okay?
Things that the 3 children has been like that is
If
Lots
you
of-
had 3 children, your
lots of-
conduct should not be like this.
lots of lots.
Your
Lots of-
conduct should not be like
Lots
this.
of lots.
Do you get my point?
Lots.
Don't open.
Most important condition may be local surety.
Local surety, that we'll do. That I'll do, don't worry.
Lots.
But Mr. Counsel, this is not a money suit.
That is true, my lord. There are many more persons
Okay,
whose money has been misappropriated.
okay. Next.
I have objected to bail application.
Why?
Since after getting interim bail, he is not cooperating.
No. This court has not directed me to appear, Your Lordship. Lordship, kindly go through the last order. My friend will kindly go through the last order. This court has not directed me to.
So
appear.
that would mean that you will not cooperate with the,
No, Your Lordship, I have not been called again. I am ready to come tomorrow itself.
Mr. Learned PP, from the case diary has submitted that the accused, the petitioner, in spite of being extended with the benefit of interim anticipatory bail, has not appeared before the IO. The said position is disputed by Mr. P. Bhardwaj, learned counsel for the applicant, who submits that he has not been summoned by the IO. In view, be that as it may, the petitioner shall, within a period whereby shall on or before 10/6/2025 appear before the IO and have his statement recorded. Registry to list this matter again on 16/6/2024 with a full stop. The learned public prosecutor shall furnish an updated case diary of the connected case on the next date of listing. Full stop. Interim order passed earlier to continue till 16/6/2025 with the further stipulation that the petitioner shall appear before the IO on or before 10/6/2025.
Specifically, when should the order man? There was no direction. I am not.
That you are taking advantage.
No, man.
That you are taking advantage, Mr. Bhardwaj. Once you have got a bail, it's your duty to be there. Maybe sometimes it's just missed out, but that you are taking a technical plea. Now you appear.
I will appear.
You get it. You know how to deal with it. He'll appear before you on 10th. Do whatever cross you want, temporary arrest.
Publish.
Then come back. Anybody appearing for the respondents?
Yes, ma'am.
You are appearing.
My lord, I have filed Wakalanam on behalf of respondent 2 and 3.
2 and 3.
Yes, I'll also be filing for respondent number 1 now.
So how many respondents?
3.
3.
Full stop. Seen the office note dated 25/3/2025. Full stop. Service upon the Miss N. Dangan Learned Council appears for the respondents number 1, 2, and 3. Full stop.
Till now, 2 and 3, I'll be appearing for 1.
1, 2, and 3.
Hmm.
Miss N. Dangan submits that she represents the respondents number 1, 2, and 3. Full stop. Wakalatnama on behalf of the respondent number 2 and 3 has already been filed by her. However, Wakalatnama on behalf of the respondent number 1 would be filed within a period of a week from today.
Yes.
Full stop. In view of the above position, service is complete. Appeal has been admitted.
My lord.
Uh,
Substantial question of law may also be framed, my lord, in this case.
Full stop. Accordingly, registry to list these matters for hearing in due course.
Oblige.
Publish.
Where is it come up for orders?
There is a two case. One is filed by the another party. That's my respondents from respondent side. The criminal petition. There is a two criminal petition. I have filed this. Criminal petition number 733 of 2025.
This is that matter wherein that girl was offered to marry
Yes,
the other wife, first wives.
Yes.
My wife had offered the girl to marry her husband.
Yes.
That is the case.
Yes,
And then she was left at,
yes.
okay, when? This is not, we'll take it up for admissions.
Yes.
Things are done. So, the, both dono mein likhna. All the parties are represented.
Yes.
It is stated at the bar that the parties to the proceeding are duly represented. Further, the trial court records have also been received. Accordingly, the registry to list dono ek saath maarte na 73 and 31. Registry to list this matters for admission hearing after 2 weeks, 3 weeks on a date to be fixed by.
Lordship, in the meantime, interim.
Interim
Yes.
orders, if any, shall continue till the next date.
Yes. May I please, Lordship? Lordship,
You will have to take fresh steps for respondent number 8.
Lordship, I'll do that.
Seen the office note dated 28/5/2025, which reflects that which reflects that the service upon respondent number 8 has not been completed. The Learned Counsel for the petitioner submits that he be granted a week's time to take fresh steps upon the respondent number 8 by way of registered post with AD as well as by way of Dusty mode. Full stop. Prayer accepted. The petitioner to take fresh steps for service of notice upon respondent number 8 by way of registered post with AD as well as by way of Dusty routed through the registry of this court. Full stop. Steps be taken within a period of 7 days from today. Full stop. On receipt of the requisites, petition registry to issue notice to the respondent number 8 in the manner directed above. Full stop. Raised it to list this matter again after 4 weeks on a date to be fixed by it.
Extra copies.
Not given, yeah, what is this?
I'll give today.
Why?
Today.
Why copy was not given?
I think I have given.
You think you were given, that means you are also not sure. Do it today.
Lordship, in the meantime, interim order dated 27/9/24 may be extended.
Interim order passed earlier to continue till the next date. Madam, you have an interim order against you, you are taking it so casually. File a vacating application. And if you don't give the copies, make a mention of the matter on Monday. That copies have not been given. I'll have it listed.
Lordship.
Seen the office note dated 28/5/2025, service report, service upon respondent, sole respondent is not complete. Full stop. Await completion of service upon the sole respondent for further 2 more weeks.
Yes, sir. Obliged.
My lord, in this case, I
You are
want,
being now treated in trims.
yes, now I have been released, my lord.
Relieved,
I have been released
release from
from
trims.
trims.
Okay, fine.
And my lord, I have been detected a TB patient.
That they will provide you all the requisite.
My lord,
TB is not a big thing nowadays.
my lord, I want to argue the main case.
Main case when you take, give me a date. When, Mr. Abhay?
My lord,
Allegations are very serious.
my lord, can it be hard today? Can it be hard today?
Today we are not hearing it.
Then in
Orders only.
in that case, let the IAB dispose of today. That may be considered.
We are not entertaining you. You are released from the thing. We'll only direct them to provide you all the requisite medical.
My lord, there is other materials. There is other materials.
You need not, because I'm not convinced.
My lord, I may be hard. I may be hard.
My lord, I am for the informant victim.
Hmm.
I have not received a copy of IA.
Oh. Yes, why a copy is not been given to the.
She is appearing for the first time. I was not knowing who has been appeared.
Miss
Jetoji.
J. Loji, learned counsel, appears for the, you are a legal aid counsel.
Yes, legally.
Legal aid counsel appears on behalf of the respondent number 2. Full stop. The learned counsel for the petitioner shall furnish to the counsel for the respondent number 2 a copy of the interlocutory application. That is IA criminal 58 AP 2023 and IA criminal 42 AP 2025. The paper book.
Yes, I have received.
Okay, full stop. Raised it to list this matters again on.
My lord, can we have it on
7th is a holiday. I'm not coming. 9th,
9? No.
9, 6, 20.
Okay. Obliged.
You have filed it, Asti.
Yes, Lordship, I filed the affidavit.
The learned counsel for the petitioner. The petitioner has filed an affidavit wherein it has been highlighted that the notices have been served upon the respondent number 1 to 6 by way of dusty mode. Notices were so served on in the month of April 2025. However, none has entered appearance on behalf of the said respondents. Full stop. Or you want me to consider the
Yes,
delay?
Lordship, it's only matter of 16 days, Lordship.
The present interlocutory application has been instituted praying for condoning the delay of 16 days in filing the connected civil revision petition being. What is that number? Not number. Connected civil revision petition, full stop. I have heard Mr. Hart, I've heard Mr. So-and-so learned counsel for the petitioner. Full stop. I've also perused the averments made in the interlocutory application towards justifying the delay. I've perused the contentions made in the interlocutory application. Full stop. On perusal of the reasons cited by the applicant, I am of the considered view that the delay of 16 days occasioning in filing of the connected civil revision petition is not deliberate but is circumstantial. Full stop. Accordingly, considering the averments made in the interlocutory application, I am of the considered view that the said delay is required to be condoned. Accordingly, the delay of 16 days in filing the connected civil revision petition stands condoned. Full stop. Raised to list the connected civil revision petition being CRP 29/2025 admissions on the admissions after 2 weeks. Full stop. उसमें लिखना CRP में. In view of the order passed today in IAC number 87/AP/2025 condoning the delay of 16 days in preferring the present revision petition, raised to list this matter for admissions after 2 weeks. We'll come back. There is a reference in the central, what do you call that? Reference, farewell reference of Honorable Chief Justice. Just attend that and back.
this one. I mean, in that case, Lordship may pass any order as being.
Madam, you are appearing for?
Yes.
23.
Respondent number 4.
She is
She's four.
appearing for respondent number 4.
Yes.
Okay. But Mr.
Yes.
G. Tarak
I
Lanak.
have filed my affidavit already, Lordship.
You have filed your affidavit. You are for the deputy commissioner
Yes, Lordship.
and you are for
1, 2, 3, and 5. Planning Council RD, madam.
but Mr. G. Tarak Lanak, counsel for the petitioner, also heard Ms. So Lanak, counsel, government advocate appearing for the respondent number 4. Right.
Yes, Lordship.
And Mr. So standing counsel, rural development department, Department of Rural Development appearing for the respondent number 1, 2,
3,
4, 3
and 5.
and 5. Full stop. In view of the nature of the order being passed by today, comma, in view of the nature of the order being passed, comma, service of notice upon the respondent number 6 and 7 is deemed to be not necessary. Full stop. The petition has, by way of instituting the present proceeding, presented a challenge to the engagement of the respondent number 6. Respondent number 6. Jumkar Marde as computer assistant in the establishment of the project director, Department of Rural Development, Upper Subansiri District, Dapurijum. Full stop. It is full stop. Subpara. It is the petitioner in the petition has contended that on a vacancy arising in the post of computer assistant existing in the establishment of the respondent number 3, comma, she had submitted an application before the Director, Rural Development Department, Commissioner MREGA for consideration of a case for consideration of a case for engagement against the said vacant post of computer assistant. Post of it is contended in the writ petition that basing on such application, the Director Commissioner MREGA, while order dated 5/3/2025 had granted approval for the engagement of the petitioner against the post of computer assistant falling vacant on the resignation of Sri Bomkar Pagman, who was the incumbent therein earlier. So, it is the Upper Subansiri District, Dapurijum, that is the respondent number 4, for issuance of the consequential order of appointment. However, the petitioner was denied an appointment on the ground that the respondent number 4 had already appointed the respondent number 6 against the post of computer assistant on 26/2/2025 itself. Also, being aggrieved, the petitioner has instituted the present proceeding. Also, the respondent number 4 has filed an affidavit in the matter and therein has submitted that the engagement of the respondent number 6 was so made in terms of the prescription made in an office memorandum dated 28/6/2026, wherein it was prescribed that while there shall be no recruitment on regular basis, all posts under the National Rural Employment Guarantee Scheme shall be so made on contractual basis by the Deputy Commissioner of the district concerned on behalf of the state government, and such engagement of the candidate would be for a period of 6 months initially, which would be further subject, which would be further permissible to be (2006), it is seen that the powers of engagement of contractual staff under the National Rural Employment Guarantee Scheme is being conferred upon the jurisdictional deputy commissioner on behalf of the state government. But the power of engagement of contractual employees under the National Rural Employment Guarantee Scheme is delegated to the jurisdictional deputy commissioner by the government. Also, accordingly, the order dated 5/3/2025 passed by the director requiring the engagement of the petitioner herein as computer assistant in the establishment of the respondent number 4 cannot be said to be an order so passed by passed in connoissance with the provisions of the office memo computer assistant on a vacancy arising therein, and such appointment having been so made prior to the passing of the order dated 5/3/2025, it is found that the no right of the petitioner in this connection has been infringed with. Also, it is to be noted that in the order dated 5/3/2021, while it was stipulated that approval was granted to the engagement of the petitioner as a computer assistant in the establishment of the respondent number 4, the conditions stipulated in the order, more particularly condition number 2, mandated that a formal contractual appointment order shall be issued by the respondent number 4 after observing all codal formalities. Also, they said position goes to further reiterate that it is the appointing authority in the of such engagement by the state government, and the director rural development has got no jurisdiction to effect or direct effecting of such engagement. Full stop. In view of the above position, this court is of the considered view that the engagement of the respondent number 6 effected while order dated 26/2/2025 as a computer or assistant in the establishment of the respondent number 4 would not mandate an interference, and accordingly the same would not mandate an interference. Full stop. In view of the above discussion, the writ petition is held to be devoid of any merit, and the same accordingly stands dismissed. However, there would be no order as to cause.
Bless.
Good evening.
Much.
Your name?
HP Fukan.
I heard Mr. H.P. Fukan, learned counsel for the petitioner. The present application has been instituted praying for condonation of delay of 198 days in filing the connected appeal against the impugned judgment and award dated 8/8/2024 passed by the learned member Motor Accident Claims Tribunal, West Coming from Bomdila in MAC case number 2022. So issue notice. Petition applicant to take steps for service of notice upon the respondent number 1, 2, and 3 by way of registered post with AD, along with as well as by usual process. Also, steps be taken within 3 days, 3 working days
7
from
days,
today.
yeah.
Also, raised to on taking of such steps by the applicant, registry to issue notice in the to the respond number 1, 2, and 3 in the manner indicated above. Matter be listed after 4 weeks. Affidavit by review. Yes,
Your Lordship, this court has granted interim relief only on the
today
contention
we are,
that
you're for the,
I'm for the applicant.
oh, yes,
I'm for the sole respondent. In IA,
who is for the petitioner?
I am for the petition.
Ah.
Yeah. Lordship, we will need some time to file our reply.
No. We had passed that order
Yes, Lordship.
holding that you were denoted as AE or something.
APORE.
APORE.
Yes, Lordship.
And that although it was submitted that was erroneously done, we proceeded to hold that there was no order correcting it or withdrawing. Now for vacation also you want so much time, no? The learned heard ISC 139 AP 2025. Huh? The learned counsel for the opposite party number
5.
5
Applicant
submits oblique repetition submits that time till 4/6/2024 to bring on record his objections to the interlocutory application filed by the applicant. Who's up?
Lordship,
Prayer accepted.
if you are given a little bit more time.
No, Your Lordship, he's enjoying the
No, Lordship, actually our contention
interim
is,
relief since December. Your Lordship.
Okay, I vacate his stay. Where will he go?
He will have his
He has his own post.
own force.
Lordship, our.
He's a TA. Also.
Lordship, our main contention is that in that list, all the APOs.
That they have now, Mr. Counsel, they have now, I have gone through it. They have now said that was the error and they have clarified that position.
Lordship, our.
There is no order. You show me an order.
That is their.
You show me an order that you are an AOA.
Lordship,
APO.
APO. Lordship, the name of all those APOs, they are all not regularized, including us. Only 3 of us has been targeted by the police.
In their
Okay.
petition also, they have annexed a
Okay.
document.
When did you file this?
Yes, yesterday.
Yesterday. 14 days he gets. He gets 14 days
Yeah.
before 2263 kicks in.
We received the copy only yesterday, so.
Okay. Yesterday was 28. On or before 11/6/2025. Also, raised it to list this matter, no, or before 10/6 again. Raised it to list this matter again on 11/6/2025. No further time for filing of objections shall be granted to the respondent. Enough?
Obliged.
Interim order is limited by time?
No, no.
It's.
Yeah.
I'm for a respondent, inform Mr. Bode, my lord, has some difficulty today, so he's not
It
here.
is submitted at the bar that Mr. Bose, A. Bose, no?
D Bode. D Bode.
D. Bose, learned counsel for the appellant, is not present in the court on account of certain personal inconvenience. Mr. D. Panik submits that he would have no objection in the circumstances arising for an adjournment in the matter today. So accordingly, raised it to list this matter after 2 weeks on a date to be fixed by.
Chair, Mr. Call. Sir, my lord, long pending matters, but some issues has cropped up, my lord.
Hmm.
BNS. Your lordship kindly peruses the order dated 18/3/2024.
Right. Because now the appellate authority is the civil judge junior division. From Cayman.
No, appeal was filed against the decree of the, my lord, civil the senior division. Now earlier, my lord, in terms of the registrar general case, the honorable division bench of the honorable court, my lord, held that the Bengal Agra Civil Courts Act, Assam will apply. So there, my lord, Bengal Agra Civil Court, no issues, my lord. Now, by an amendment, I think it is 10 or 20 lakhs, they will directly go to the High Court. Now it says 15(2), appeals from decrees and order passed by a court of civil the senior division in original suits and proceedings of civil nature shall, when such appeals are allowed by law, lie to the court of district judge of the district and my lord, hereafter will see, or in the court of the additional district judge where such court exists, or the High Court as the case may be. Now, what is the case may be? There is nothing here in the act.
But this has been again amended.
No, my lord, this is the
Latest
provision.
amendment.
This is the provision.
No, this has been amended, I suppose.
No, my lord. 15(2) is not amended. Provisos of 15 is amended, 15(3), 15(4), but 15(2) is not amended.
No, that where is that provision with regard to
My lord.
the appeal from customary courts, Kebang and all?
That, my lord, here in the proviso itself, you also will find, then there is an amendment thereafter. Ours was a suit directly before the civil the senior division.
Oh, yours is a suit before the civil judge.
Yes.
Okay.
So accordingly, my lord, mistakenly, initially we filed before the district judge. Since the Bengal Agra Civil Court was applicable at that point of time, we had to withdraw that came before this High Court. So now, after the coming to force of this act, this question was raised. Now, my lord, this is a provision. This is almost perimeter with the language used in 438 earlier CRPC and 482 CRPC. So there, my lord, when the word is used, or the High Court, the sessions of the High Court, we oppose either the sessions court or the High Court. This is the language, my lord, I don't know.
Or as the case may be.
I don't know. That is the problem. The case maybe is not here.
The case maybe would be that if there is a pecuniary jurisdiction prescribed, then if the pecuniary jurisdiction is within the district judge additional additional also does not have. Yes.
They
What
forgot.
is your take on this?
My lord, what appears what? I don't want to say this, but what appears is Bengal Agra was being used all the time.
But now they have come to the court.
Yes, now they have enacted this statute. They forgot to insert that part. It appears so.
We'll ask the Advocate General to assist.
Yes. Otherwise,
Or is there an additional Advocate General? Mr. Ratan is there?
Mr. Ratan will not be able to appear. He earlier appeared for a private party.
Oh.
But because of the plain language of the act, it would be similar to 438, 482 now. What I understand, my lord. Either I can approach the district judge. Or
It's an option.
Yes. That is
Dominus litis.
Yes.
What do you call that? What is your take on this?
Worship, I'm in item number 33. So, my humble understanding is that CPC should be, section 15 of CPC should be given.
Give me
to
your
us.
CPC. Photo.
May I read? Court in which suits to be instituted. Every suit shall be instituted in the court of the lowest grade competent to try it. So
this is a
Yes,
appeal.
that is not even.
yes. So now we have
They
to.
had instituted, the suit institution is perfectly fine.
Yes.
Hmm.
Lordship.
So
Now-
now it's a question of appeal.
Yes, now appeal. Appeal also, Lordship, here we have to see that if there is a district judge available, then it has to be filed there because this is a procedure law. Procedure law should be given to the responsibility effect because
You mean to say that the
2000 is-
second appeal only will under 100?
My lord, that part in Assam, my lord, this question is arisen that order has been passed by Justice Siam just because after the, my lord, amendment of the Bengal Agro Civil Courts Act, 5 lakh was raised, I believe, to 20 lakhs. So that is why all those suits were within 20 lakhs were transferred back to the district judge. Now, what my learned friend is submitting, that if that interpretation is given, my lord, the whole interpretation of CRPC 482 now, BNS,
No.
will go away.
Well, if I have understood what he means to say is that he means to say what has happened subsequently has happened subsequently. If the jurisdiction was with the High Court when the appeal was filed, it continues to be with the jurisdiction with the High Court. And
I would very well like that. I don't want to go
but-
to the district judge. now.
but the
But this
issue
should have
may
to
not
be-
be that
the
because
issue
the
is not
issue
that,
may
no.
not be
Hmm.
correctly, that may not be the correct
Yes.
interpretation because during a pendency of a suit, if the jurisdiction is taken
Yes.
away, then from that day I can't have a jurisdiction.
Exactly, that is why the entry order came to pass, because in Guwahati, after the amendment of the Bengal Agro Civil Courts Act, raising it from
Everything
5
was sent back.
sent back, yes, that is why.
There is some lacuna here.
Apparently, my lord. If your lordship kindly have a look at the BNS 482, the language used is almost same. The word is used in High Court or the Court of Session.
If given
is
to
now-
me, if given to me, the interpretation,
Yeah.
I will go with the first line and say that it is the district court. Go with the first line. It is specific to the appeals emanating from the Court of Civil Judge Senior
Senior
Division.
Division,
In original suits and proceedings of civil nature shall, when such appeals are allowed by law, lie to the court of the district judge. We need not.
It will-
Pecuniary limit. Otherwise, there cannot be this. You
Yes,
can't have
yes.
two forums.
yes. It will, but we will
Because
take
what
note
is
that,
happening
when
is,
the district-
Mr. Manning, what will happen is, this will be a first appeal.
Yes,
Where would the second appeal be? Supreme Court.
no, my lord. When there is, the institute does not provide.
Provide finish.
Then we have
But-
to go by 227.
This cannot go contrary to your code also, because the code is also defined here, applied.
No, my lord, if your lordship helps, say supposing in the other cases, that say supposing from a decision of the village authority, we come before the first appellate court, that is the civil judge senior division. Thereafter, the issue now has arisen that whether a second appeal will lie directly to the high court or a civil division petition will lie. That is
I've
another issue.
examined that, I've also heard. The issue is customary court, end of the matter. That's a decree.
Yes.
So appeal lies, section 96 or 41, whatever it is, appeal lies to the civil judge, junior division, senior division, and the district judge. Why? Because there would be pecuniary considerations. Now, if an appeal is filed before the civil judge, senior division or junior division, whatever it is, that becomes the first appeal, RFA.
Yes.
Now, if there has to be a second appeal, it cannot be in violation of section 100.
Yes.
So it will be to the High Court only, no, not to any other. So you can't have a proceeding, a second appeal, further appeal before the district judge.
But my lord will see, because this will have to be understood in the manner in which this was enacted. There is an intent will have to be seen. Because earlier, in terms of that, my lord, Registrar General judgment, the civil courts were exercising jurisdiction in terms of the Bengal, Agra, Assam Civil Courts Act. There, this pecuniary jurisdiction was there. This act, my lord, instead of, my lord, clearing things, has created more. There are criminal jurisdiction also, village authorities, theft, mischief. My lord recalls when this, my lord, in the principal seat, my lord, when this order was passed by the then Honorable Acting Chief Justice.
Okay,
438.
got it. Answer is at section 23. 2.
Yes, yes.
This is with special act.
Yes.
But here it says every order of the district judge, court of district judge, passed on appeal under subsection 2 from the order of the so and so shall be subject to an appeal to the High Court under the rules contained in the code applicable to appeals from appellate degrees. So this is second appeal.
My lord.
Every order made by a civil judge senior division by virtue of powers conferred upon him under subsection 1 shall be subject to district judge. Although this is under the special act.
Yes.
Special acts, but this can throw a light for interpretation of
Yes.
section 51. 15. Every order made by a civil judge senior division, your scoot was instituted before the civil judge senior division. It will be before the district judge. Let us not rush. It is
Yes,
already
yes.
there from 17. Let us not rush because this will have a
Yes, it
big,
will have a ramification.
you examine, come up with the arguments, we'll conclude it. Because that point decided, we'll take it as a preliminary point raised by him. Mister, we'll take it as a preliminary point raised by him, then come to a conclusion on that.
Yes.
You address us a bit more.
Yes.
You do some work.
Yes, this
When-
part, my lord.
This is not applicable because this is with regard to special acts. But even if it is special act, the institution of a suit under 9 of the code will be before the civil judge senior division.
Yes.
Now what happens? From there it says not the High Court, appeal will be before the district judge. First appeal.
That would be in respect of when these powers are invested upon this.
No, you forget one. Just for the second, you forget one. Once a suit is invested,
yes.
See, whether it's a special act or a general section 9 application, whatever it is only for the purpose of institution of a suit that power is conferred. Once a suit is instituted, say I am a competent court, suit is instituted before me, then this will kick in.
Yes.
So it will be considered under this. Moment it is considered under this, a decree comes, then it says it will be before the district judge. And further appeal, if required, would be before the High Court in connoissance with this.
Yes.
Why the same cannot be applied in 15 also?
My lord, because in special judges, this concept of, my lord, appeal under section 100 may not come in also.
No, if it does,
institutes, my lord.
if it does, that's why it's provided here. Every order of a court of district judge passed on appeal under subsection 2 from the order of so and so shall be subject to an appeal to the High Court under the rules contained in the code applicable to appeals from appellate degrees. So this, even if there is a bar, it will not be there. If it is a bar, that special act will hold it. But if it is not there, then this procedure, original suit, RFA, district judge, or additional district judge as it may be, and then High Court, second appeal.
Yes,
And that is, I think, in tune with 96. Appeal from original decree.
That is something different, but conferment of jurisdiction, my lord, to the appellate courts are
No,
in
no.
terms of the special act.
This is, forget 23. Yours is not under a special act. Is it under a special act? Your suit?
No, man.
It's a general suit.
Yes.
Now, general suit, it will be the code that will
Yes.
hold the fit.
But confirmation of jurisdiction is under the Civil Courts Act. At that point of time, under the Bengal Agra Act.
Fine. Today, that jurisdiction has been changed.
Yes.
Now, save as a board or by any other law for the time being in force, an appeal shall lie from every degree passed by any court exercising original jurisdiction to the court authorized to hear appeals.
Yes.
From the decision of such court. An appeal may lie from an original decree. No appeal shall lie. No appeal shall lie. Now,
Authorized, my lord.
authorized. So authorized is district judge, additional district judge, high court. And it's a normal suit.
Yes.
Right?
Yes.
There is no bar for a second appeal. Huh?
No.
Then how can we ignore that? We can't take a forum away. Either of the parties may have to go for a second appeal. We can't take, although it will be on a substantial question of law, we can't take that forum
No,
away.
no, that cannot be taken away, man.
Then-
That cannot be taken away. But my lord will say, in Assam, my lord, that is in terms of the Bengal Agra Civil Courts Act. Appeals beyond 20 lakhs comes directly before the High Court. It does not take away the power of second appeal, my lord.
No, that is because there is a pecuniary jurisdiction. If that pecuniary jurisdiction is removed, then again we'll have to fall back on the hierarchy of the courts. That's why I said,
Yes.
if the district court is entitled to hear an appeal, say 15 lakhs, district judge and additional district judge, 15 lakhs or 50 lakhs. Above that, high court, no issue. No issue. But here there is no pecuniary
That
jurisdiction.
is the difficulty, man.
There's no pecuniary jurisdiction.
What I am trying is, let notice be issued to the Advocate General. Maybe they will do the needful also. It was obviously in their mind.
Also,
It was
but
obviously in their
Mr.
mind.
D. Panik, learned counsel for the petition also. You are appellant in all the cases?
No, my lord, I am
In
in,
item number 33, I am the appeal.
Okay. All the three appeals will tag it up together. It's already
Yes,
tagged up. Heard Mr. D. Panik, learned counsel for the appellant in RFA number 6 AP 2017. Also heard Mr.
You Bori.
U. Bori, learned counsel appearing for the appellant in RFA number 3 AP 2017. And you are appearing in?
I have for respondent number 1 in all cases.
Okay. And who is there for the RFA, third RFA? 5?
But if we, earlier in reference.
Also heard Mr. So-and-so, learned counsel appearing for the respondent number 1 in all the above noted appeals, full stop. During the course of the hearing of the present appeals, an issue has arisen as to the manner in which the provisions of section 15 subsection 2 of section 15 of the Arunachal Pradesh Civil Courts Act 2021 is to be interpreted with regard to determination of a forum for preferring an appeal from the decree passed by the Court of Civil Judge Senior Division in original suit instituted before it. So while the learned counsel for the appellants would like to contend that the appeal, given the language of subsection 2, language in which subsection 2 of section 15 is so couched, would be either before the district judge or the additional district judge or the high court, which is contended to be a choice required to be made by the appellant. So the learned counsel for the respondent number 1, however, submits that considering the provisions of section 96 and 100 of the Code of Civil Procedure, when read to the district judge inasmuch as no pecuniary limit in the state of Arunachal Pradesh is prescribed for entertainment of appeals by the district judge and or the judge, as the case may be. So, in view of the above position, this court is of the considered view that the considered view that it would be considered view that the addition that the Advocate General that the learned Advocate General Arunachal Pradesh is required to be heard in the matter. Accordingly, a notice be issued to the office Advocate General. The notice is issued directly to the Advocate General or the office of the Advocate General.
Then I'm not sure. Issued to the Advocate.
Accordingly, the Advocate General is requested to assist this court in the matter on the next date of listing. The learned counsel for the appellant shall furnish a copy of the appeals along with the other pleadings to the office of the Advocate General, along with a copy of downloaded copy of this order. Done?
Yes.
Full stop. Registry to list this matter again on after 2 weeks, 3 weeks on a date to be fixed. You have a date from the Advocate General?
Yes, yes. If it was held that since the appeal was filed before the coming into force of
That
this act,
may be difficult.
yes, I would have been very happy.
I
Now going back to the district judge again.
This will only be a transfer.
Yes.
Otherwise, you will have to file a delay there.
That is why.
Section 14
Yes.
again. Anyways,
Obligement. Maybe I am hoping now once the Advocate General appears and once notice, maybe they will do something about it.
maybe.
Quickly apply.
Me.
Yes, my lord, this is long pending case, my lord. Yes, my. My lord, there was advertisement for selection of LDC in the district of Lohit, my lord, Teju. Altogether, there was 14. Five 2016. My lord, the exact force, my lord. Yeah, my lord. Yes, my lord. Yes, my lord. Yes, my lord. I am sorry, my lord. The total number of posts was 13, and 11 was for APST, and 2 posts were kept for this general candidate, my lord. General 3 and 4, my lord. Yes, my lord. In view of the fact that, my lord, because I am not domiciled from this district. Yes, my lord. Yes, my lord. Yes, my lord. Yes, yes. Yes, my lord. Now, accordingly, my lord, I have also participated, my lord. I did well in the written examination, my lord, even in the Bible was, my lord. My mark, my lord. My lord. My marks, my lord, 250 and half, my lord. Yes, 252 half, my lord.
250.
Yes.
Yes, my lord, yes, my lord, 250 and half.
And respondent number
3, my lord, he was awarded 253 half, my lord. 250. 250.
So your case is there, a case against or against the respondent number 4. One of them will go according to you.
Yes, my lord.
So the only thing
This
is R3.
R3 will go, my lord, if I succeed, my lord. My lord, basically, my contention in this writ petition is that, my lord. Of course, it is also not disputed, my lord. I was not awarded 4 marks, my lord, for 2 questions. Yes, 2 questions.
So you are limiting that for 2 marks each you are not awarded.
Yes, my lord. I'm not limited to that, my lord. Initially, that was my this contention, my lord. After they have filed their written statement, I have filed. Yes, my lord. Yes, my lord.
Please take all the points that
Yes, my lord.
how the marks would be, is how much marks increase will you have? According to you.
According to me, my lord, 4 marks, my lord.
4 marks.
Yes, my lord. Yes, my.
You are given 4 marks. You come before R3.
R3,
Which are the questions?
my lord.
Which you will have.
The question number, my lord, question number 36 in GK paper, my lord.
Page
Page number, my lord, 52. Option D, which is Samudra Gupta, my lord.
that means to
My lord. My lord, let us compare this answer with the answer given. Then, my lord. Question number 4 of the computer paper, my lord, at page number 55. Page number 55. And rearrange file and use this space to optimize operations. C, option C, my lord. My lord, because it was permitted to entire candidate that they can have the second thought, my lord.
they can have a
Yes, my lord. If they find that, my lord, the first one, he has ticked mark, it is wrong, then he can go for second thought and the second.
Mr. Counsel,
Yes, my lord.
now that we are technical, you are technical,
Yes, my lord.
and examine your marking pattern. The answer is correct marking pattern I see.
Yes, my lord.
Every tick is on the left hand side.
Yes, my lord.
It is only for question number 4 that there is a tick on the right hand side. Whereas earlier B was tick, you crossed it.
My lord.
Why was the tick not given in the left hand side over C? Because that is the key exactly taken up by the response.
Yes, madam.
My lord, that instruction, of course, I do not have, my lord, but this is my case, my lord.
So if 2 marks goes, if this is disputed, you only get 2 marks.
Yes, my lord.
You're not
That is,
getting anywhere.
that is true, my lord. My lord, since my lord, they too have opted the second thought, my lord. My lord, I have even this walkout. Many questions, my lord, there.
Yours.
My lord, my lord.
So 2 marks, 1. So it's only 2.
Yes, my lord. But my lord, since that was permissible, my lord, that was permitted, my lord. So
Where is that P taken? Madam, where is that P taken? That I taken a specific P.
Lots of because.
Yes.
Yes.
my
You can find that.
Yes.
Yes.
Specific P. There is on the. And if there is, one more thing, sir. Is there any case read out by you that their marks will also have to be done?
yes, my lord.
How many marks?
6 marks, my lord.
6 marks.
Yes, my lord.
Of respondent number?
3, my lord.
3.
Yes, my lord.
That has also been dealt with by the authorities. They say that respondent number 3 and 4 are entitled to more marks.
My lord, this other case is my lord. My lord, this is my writ petition, my lord. It is the petitioner, my lord, who is agitating before this honorable with his grievance.
Respondent, we see whether you are entitled to it. That's all.
Yes, ma'am.
Okay.
Regarding question number 4, my lord, page number 8 of my affidavit. Me. Respondent number 2. Just a second. Mukesh Thakur is respondent number
3 and 4.
maybe 3. 3, madam. 3.
Wherever the agreements are just made up of tag mark.
All right.
Will come back.
Yes, ma'am.
Yes.
Yes.
You all need not wait. Both the matters have been disposed of, but you will get the copies only by Monday because there is a connectivity problem here. Monday you will get the copies. Okay?
Well, both the matters are disposed of.
Okay?
Well, oblige.
My lord,
Which court are you from? Which court are you sitting there? 23? No.
no, it is in the old building, court number 2, my lord.
Okay.
That vintage court. My lord.
Looks nice from here.
Now, my lord,
Okay.
may I pray, my lord, for one thing, my lord, that item number 2, that is the jute mills case. My lord, if lordship is disposed of, my lord, may I know the result, my lord?
You will get it on Monday. Don't worry. Just wait till Monday.
All right.
It's been typed out. That's why Monday I'll give it.
All right, my lord.
Disposed of, no? Just tell Papuri maybe there. Just tell her that it's been disposed of. She'll do the proceedings there. Medium name, Papuri, that my court master there. No need, finished. Give the unlisted ones, finish it. We'll just, there are 3 unlisted matters. We'll just finish it and then come back to you.
Shall we wait, my lord?
No, you can go.
Lord.
You will have the orders by Monday.
Simply applies, my lord.
Where is the FIR?
The
Same,
Your Honor.
same police case.
Same
Yes.
FIR.
Your Honor, this is a urgency matter.
Drugs.
Your Lordship,
Drugs recovered from your possession.
none from my position.
Then?
Your Lordship, I was traveling as a co-passenger. Your Lordship, as far the
What was the
prosecution-
vehicle?
Scorpio, white color Scorpio.
Okay, what were you doing there?
Your
How did
Lordship,
you come into that vehicle?
I was coming toward Bandadua on account of my personal urgency work. So at the meantime, during the journey, I
What is
met
your name?
Anil
Ainul Haq.
Haq.
Moinul Haq.
Ainul Haq.
All these petitioners were taken into custody from the vehicle itself.
Yes, Your Lordship. They are all arrested and perhaps, Your Lordship, they are in custody for 47, 42 days.
44.
54 days.
Your Lordship, here also.
What is the limit?
60 days, Your Lordship. It's
60
21B. So if punishment is not minimum should be 10 life or death. Otherwise, Your Lordship, 60 days.
Get your CD.
Yes,
Or
Your Lordship.
what do you propose?
And Your Lordship, the ground which they have taken, Your Lordship, I will clarify in the motion stage, Your Lordship. They have taken the ground of arrest has not been communicated to them. Your Lordship may kindly come to page 22. That Your Lordship, that Bihan case was referred, but this will not applicable in this case. So Your Lordship may come to page number 22, Annexure 3. Your Lordship will find in serial number 30. There below, Your Lordship will find recused from committing any further offense. Yes, ground for arrest. For proper investigation of the offense to prevent the accused from causing the evidence of the offense.
Yes,
This ground is given. So ground goes, ground for non-communication on ground goes, Your Lordship.
What is the stage of the investigation? Charge ready?
No, investigation pending, perhaps.
Pending, Your Lordship.
You get your instructions.
Yes, sir.
Your Lordship, here, as learned PP has said that the ground has cited. The ground actually has not cited. The ground has to be very specific.
Okay.
On what ground
Okay.
the accused has been
Now,
arrested.
now I don't understand this. Explain. What is meant by ground of arrest?
Ground of arrest, Your Lordship, at the time. Obviously, of
The
course,
material has been recovered from you.
not recovered from my possession.
That vehicle?
Vehicle.
Vehicle.
Yes, Your Lordship. But Your Lordship,
And how many persons were there in the vehicle?
3% at the time of recovery.
Recovery. 3 persons were there.
Yes.
So you are appearing for all the 3?
Yes, Your Lordship.
So the other 2 grounds also, you are taking this same very plea? Grounds of arrest not given?
Yes, Your Lordship.
So from your possession, drugs is recovered. Drugs was not recovered from the possession of any of the 3.
Not from the
accused.
concierge position, Your Lordship.
Not from the concierge.
It was recovered from the
But what is
inside
your
the
name? What is your name?
M. Kamcham.
M. Kamsa, learned counsel for
Kamsa.
the petitioner. Also heard Mr. Learned counsel, learned additional public prosecutor appearing for the state. So the present interlocutory present bail application has been instituted under invoking the provisions of section 483 of the BNSS 2023, seeking a release, seeking enlargement on bail of the Ainul Haq, who was arrested on 12/4/2025 in connection with Bandadua PS case number 33/2025 under section 21 bracketed B of the NDPS Act 1985. Read with section 3 bracketed 5 of the BNSS full stop. Issue notice, the learned additional public prosecutor shall receive the scan copy of the case
Yes,
diary,
scan
scan copy of the case diary and place this thing before this court on the next date of listing. ये तीनों केस में सेम होता, तीनों केस में होता, खाली आपका वो पार्टी का नाम चेंज हो जाएगा, देख सकेगा ना? This this matter again on when?
Your Lordship, the accused person in bail application number 36, his wife is suffering from medical issue. Your Lordship, she is suffering from abdominal pain. Currently, she is going a medical treatment, severe abdominal pain. So therefore, Your Lordship, the sword may be given.
Where is that item number? Which one? Item number?
36.
36.
Number 30, 65. Your Lord.
Well, 65. That is a lady.
Yes,
Hasina
64,
Khatun.
64.
64. And these are residents of which place?
No,
Assam or?
Assam. Page number 24.
Jagir Road, District Manigaon, Assam.
Whose vehicle it is? Who is the owner of that vehicle?
Emmanuel Hussein.
Hussein. And who was driving the vehicle?
Emmanuel Hussein itself.
He is not a petitioner here.
No, he is also petitioner. Item number 66 maybe.
Bill number application 65.
65.
65. Hasina Khatun.
Yes.
Okay, she is she is the applicant. Accused is Inamul,
Inamul Hussain.
and whose wife is undergoing treatment?
Inamul
Hakim.
Tafazul
Islam, yes, sir.
Tafazul Islam.
M36.
Where is the material?
Page number 23.
Tafajul Islam, Your Lordship. How he can file a bail application from jail, Your Lordship?
Tafiqul Islam is a foreign law of the accused.
Accused name is
Accused name is
Tafazul Islam.
Tafajul Islam.
And he is
an
filing
applicant
this
here.
bail for
Emmanuel Haq.
Okay. Okay, when can you get the case ready?
it is, Your Lordship, 1 week time maybe. Granted.
Okay, 9/6.
You're not giving me a short date.
9/6. 9/6. 1 week, 9/6.
Oblige.
This is not written. Okay. So two questions, question number 36 and question number 4.
Yes.
Okay.
After that, my lord, when I have found the discrepancies, my lord, through RTI, my lord, of course, all these documents, my lord, my answer script and the answer script of the respondents. I have initially applied for the for furnishing of.
They did not give you,
They did,
then you went
not-
up to
yes,
the
yes,
Information
my lord,
Commission.
yes. Then, my lord, after detecting the ambiguities, my lord, affidavit. I have made a representation, my lord, submitted a representation on 16/2/2018. My lord, may kindly come to my representation, my lord, at page number 109, ma'am. My lord, why this representation, my lord? I was seeking, my lord,
No, 36, I'm giving you 2 marks. Don't worry. Show me the next one.
Question number 4, my lord. Yes.
What is the name of R3?
R3, Mukesh Thakur. Mukesh Thakur.
R4?
R4 is
Pallavi.
Gogoi. Now,
Just a minute.
my lord has seen my representation.
I'm giving you 2 marks.
My lord.
Question number 36, I'm giving you 2 marks.
My lord.
Forget it for the time being.
Yes.
Now come to question number 4.
Yes, my lord. That, my lord, I have, in my representation, my lord, I have mentioned. my
Okay.
lord.
Question
That
number
will be-
4, both me and option C, 2 marks were given, and I have been discriminated by not awarding marks for the same answer.
Yes, my lord.
Now, 2, we find that there is a that you had ticked B, then you had given a cross.
Yes, my lord. That is true, my lord.
So that marks cannot be given to you.
My lord, my humble
That is,
understanding, my
this
lord.
is an examination, Mr. Counsel. You will have to follow some norms. If you're not following those norms, they are rightly not denied you that
But my
mark.
lord, there, since my lord, you.
Okay, where is that question paper of the respondent number 4? Answer paper of respondent number 4 pertaining to question number 4.
Is at page number 55, my lord.
55 is yours.
101, my lord.
101.
It is, this is answer the script of correspondent number 4, my lord. 101, my lord.
101.
Answer the script of respondent number 4.
She has correctly given C, this fragment, and that is that marking. Where is the how to mark? Is there any norm set out?
No, my lord. There is no prescribed norm. Only, my lord, in the institution, my lord, it has been provided that, my lord, if the candidate, my lord, after taking any option, my lord, and subsequently, if she or he has a doubt, my lord, he can proceed and take another one. So the option for my lord second thought was, my lord, permitted, my lord. And there is no specific prescription, my lord. That
Okay.
it has to be, a tick mark has to be given in the right
Okay,
side and the
Okay,
left side.
okay.
my lord.
But in your whole answer script, you have mark on the left side.
My lord.
So why should we take it?
My
If
lord.
the what do you call that? The examiner will not record that because he has found you marking on the left side all along.
My lord is, I am submitting, my lord. There is no specific, my lord.
Okay.
Provided, my lord, the answer, tick mark or the cross has to be given either in this left side or in the right side, my lord. Only my lord, the instruction was that the candidate, my lord, has an option, my lord, for second or my lord. That I exercise, my lord. And my lord, after I have discovered the discrepancy, my lord.
So these are the only 2 discrepancies you have.
My lord. That is pertaining to my answer script, my lord. So in the year 2018 itself, my lord, I have made a representation, my lord, but they did not answer.
We have seen your representation, page 109.
That's, yes, my lord. Set over it, my lord. Only when, my lord, I have approached this honorable court, my lord, they have come with this improvised version of this.
Let's see what their improvised version is. Now you take me to that improvised version. What is that improvised version?
That is, my lord, my representation, my lord, it was not attended, my lord, because
you want your representation to be disposed of?
No, my lord.
Then that is past now.
Yes.
Let us be here today. We have every material before us.
Yes, my lord.
We'll consider. Now, what is that?
My submission, my lord, is that since there is no specific prescription for this taking mark, my lord, either in the left side or in the right side, my lord. So Since there is no specification, my lord, my answer given in this question number 4 also has to be taken as correct answer, my lord. Because I too have the right for this
it is.
second option, my lord.
This is the one. They have taken that plea, Mr. Counsel.
My lord.
The affidavit filed by the respondent number 2, internal page 10. So what is your reply to this paragraph? Paragraph 10.
Then, my lord,
You have filed a reply?
yes, my lord.
Okay. Paragraph 10. Where is your reply? Paragraph 10, reply to respondent number 2, madam, the first affidavit by respondent number 2.
They replied, and in the reply, there is some other.
No, we'll have to look into that. That's why I'm looking for the reply.
My lord. I have the minor revision. On the affidavit in opposition filed by respondent number 3, my lord.
Dated?
Dated, my lord. 12 June 2019.
I got it.
My lord, in my reply, my lord, my kindly come to paragraph 5, my lord. Discuss for paragraph 5, my lord.
Please read that.
Yes. That with regard to the statements made in paragraph 10 of the affidavit in opposition, the deponents begs to state and submit that the petitioner and respondent number 3 have attempted question number 36 of the general knowledge paper and tick option D as the right answer, but the petitioner had not been awarded 2 marks. That my lord has 2 marks against her right answer, whereas the respondent number has been awarded 2 marks for the same answer. In question number 4 of the computer theory paper, the petitioner and respondent number 4 had ticked option C as the right answer, for which respondent number 4 was awarded 2, but the petitioner has been denied 2 marks, although she too had ticked the same answer, which is option C. Further, it is pertinent to mention herein that the respondent were awarded mark even for the wrong answers, such as the respondent number 4 who had marked tick option A for the question number 13 of computer theory paper was awarded 2 marks, whereas the right answer is option D. The respondent number 3 and 4.
So you have now brought in question number 13 and 15.
Yes, ma'am.
Or in case of both respondent number 3 and 4.
Yes, ma'am. And another, my lord, question number 24, my lord, I have also.
And 24.
Yes, ma'am.
That is with regard to
respondent number 3, my lord. Question number 24 of computer theory paper with regard to respondent number 3, my lord. Here, my lord, even for the wrong answer, he has been awarded 2 marks, my lord.
I think they have filed a rejoinder to this also.
Yes, the court directed us to file reply, so we have filed.
Madam Ete, you had filed this.
Yes.
Where is that? Which is the date?
Rejoinder.
Jolly Umpo, Extra Assistant Commissioner, that one?
Yes, sir. We have filed a rejoinder affidavit. This also doing authentic answers key also. 13 and 15, Lordship.
It's 156.
13 right answer is Lordship A and 15 is B. Lordship.
As per your answer key.
Yes. And here Lordship will see the petitioner's answer also and the both the respondents' answer also.
Where?
Annex in the Lordship.
That rejoinder itself.
Rejoinder itself. Page 5 Lordship.
Page 5 is annexure 2.
Annexure 2. Annexure 1 is the answer.
Page 6 is whose?
Page 6 is
Okay.
names are given also in the answer. Last one
This
is
is
4.
uh,
Yes, the 4.
who is roll number 251? What is your roll number?
My lord, my roll number.
Lord, the petitioner is annexure 4. This is an annexure 2 is exponent number 3, R3.
Okay.
26.
And R4 is
So 13 and 15.
15.
Hmm.
13A
Hmm.
and 15B also.
And about the other one, respond number 4.
4 is also page
12.
14. Page 14 also.
Hmm.
A and B.
A and D.
B. 13A, 15B.
13, I'm sorry. 15B. 15B.
B.
Where is the answer key?
So it's also in the this one.
4.
Yes, page 4.
Then what happened? Where is the petitioner?
Petitioner is lots of page 20. Lots of missing, page 20. Here her answer is 13. She have given B and 15 she have given
B, D. So 15 is wrong, 13 is also wrong.
yes.
Okay.
In every answer script, if your lordship see the my affidavit in my affidavit also lordship page 67 in petitioner's case lordship. We'll see the instructions are already given lordship.
66.
67
67. In the writ petition.
in my affidavit.
Okay.
In the writ petitions also. it
No,
will
no,
be there,
fine.
because
We-
the lordship in every
67.
lordship. Yes.
That. Yes, that.
Yes, in every this answer is great lordship. Okay. Clearly written lordship. Seven, 8, 9. In case you want to change the answer, already tick mark, put a cross on it. Lordship.
Yes.
So, Mr. Counsel,
Yes.
your case is that for questions number 36 GK and question number 4
Of
computer,
and my lord. And question number 24
computer
of,
marks not given.
yes,
Then question number
24
of
of computer theory. of respondent number 3, my lord.
No, no, you tell me about yours first.
Yes.
Only two questions.
Yes,
okay?
yes, my lord.
Only two questions.
Yes. Yes.
And for respondent number 3, how many mistakes are there?
Mistakes, my lord.
How many marks? Which are the questions for which her marks is to be deducted?
My lord, those are, my lord, question number 13 of computer theory,
15.
15 of computer theory, and my lord, question number 24 of the computer theory. In respect of respondent number 3, my lord.
Then respondent number 4.
4, my lord, I am not challenging. For this question number 24, my lord, I am only challenging the mark awarded to respondent number 3, my lord.
Okay, for 4 you are not challenging.
No, my lord. So therefore, my lord, kindly come to.
So we'll give up 4. So we'll say that you are not presenting any challenge to respondent number 4. The
Yes, my
selection
lord.
and appointment.
Yes, my lord, because I have to compare with the.
Okay. Okay. Now let's come to, Madam had taken me now to that answer key. Right?
Yes, my lord.
Computer answer key. No, keep the originals. Why trouble us?
My lord, before that, let us come to, my lord, may I take, my lord, to page number 82, my lord, because I am. This is
82 of your writ petition.
Yes, my lord.
What is that?
This is the computer theory answer script of respondent number 3, my lord.
Okay. 80?
82.
This is question number 24.
Yes, my lord. My lord, can see, my lord.
Where is question number 13 and 15?
13 and 15, my lord. 13 of. No.
Page 80.
Page 80, yes. Page 80.
So we will look at simultaneously the answer key also.
Yes, ma'am.
So 13, the correct answer is A.
Yes.
So she has given A.
As per the answer script, my lord. Oh, sorry, answer key.
Are you questioning that answer key?
Yes, my lord.
Huh?
Yes,
Then challenge that. You have not challenged
I have not challenged because it was not with me.
Then it is there before you, at least from 21. You have not challenged it.
My lord, that is why, my lord, I have annex in my region and another answer from one public.
I'm sorry, this has to be challenged. There has to be a prayer to set aside that. There is no prayer.
No.
Then we'll hold that to be correct. So 13, we don't have the power, Mr. There are Supreme Court decisions.
That is true, my lord. That is
and
true,
I have a decision of my own,
my lord.
sitting with my Lord Justice, Chief Justice, sitting in the division bench.
That is true.
On this thing that we cannot get
That
into
is true,
this.
my lord. That is
So
true.
13 is A. Right. Correct.
I'm not disputing, my lord.
Oh,
As
for me, I'll have to write 15 B. Correct.
Correct, my lord.
Then the question is
answer key.
24.
Yes, my lord.
24 is B. Correct.
B, my lord.
Correct.
But he has cross mark, my lord.
If he has cross mark, he has not marked anywhere else. Just see the original.
My lord, let me explain. Here.
You will get your chance to explain.
Only in this question, my lord.
This is of who? R3. M. Thakur. 24, he has ticked Devangiri's. He has not been given any marks. 24. This is sorry. This is the general GK. Okay, where is that computer? Where is computer?
For this one, DK, only this original is whereas I don't know if it's there.
Oh, it is here. 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 Petitioner Pallavi Gogoi Thakur. Okay. Question number
24, my lord.
24. You say he has crossed.
Yes, my lord.
But the original one, it is same. It's not crossed. That there is some printing, something has come. It's clear. This is the one. Clear.
My lord,
My lord, it has been tempered. Tick mark has been drawn a vertical.
Mr. Counsel, let him make his case out. So 24, no tampering. Originals are before me.
my lord, in my copy.
Your copy, I don't know from where you have got it.
Yes, my lord.
But the original does not even have any mark, and there is nothing to show that any remover was used here. Because if the remover was used, if you come to your page, if the remover was used, C will go. Because that line extends till C. Have you seen it?
Yes, my lord.
But
Yes.
here the C is very intact. Anything more?
No, my lord, this is only my case, my lord. Because this is only my case, my lord.
So 23, 13, 15, 24 correctly marked.
Yes,
And
my,
what is your answers to 13? You are you got 13. B, wrong. 15 is B, wrong. 24, correct. You have also got backward software. And we are not accepting your this. What was that question wherein you had cancelled and put it in the other side?
my lord,
That is question number 4.
Question number 4, my lord.
This will not be accepted because in all the answers, even where you have cancelled, you have again marked on the left side, not on the right side.
My lord, may kindly, then in that case, my lord, kindly call for the record, my lord.
Which record?
This particular.
It is with me only.
If the mark is there, my lord, my humble.
No.
understanding is that
The 36, question number 4 of your computer paper,
Yes, my lord.
you have ticked here, put a cross on the, let's see your origin, the document you have produced. Page 55. This is the one. See, you have not crossed here. Whereas in all the answers that you have given, wherein there is a crossing, you have crossed here. For this one, you have not done. They can also take the plea that somebody may have played a foul in your favor here.
My lord.
They may take.
They,
Like you have taken a
my
plea.
lord, my lord, they may say, my lord, but it is clear.
No,
from
you
the
have said
instruction,
there
my
is tampering. We don't find any tampering.
My lord, discussing about this question number 24, my lord.
24.
I'm on question number 4 of
4.
Yes,
You have
my
rightly so. It is the discretion of the examiner. Will not come in.
because my lord, as per the instruction, my lord, my lord has
As per the instruction,
his
every candidate, including you,
yes, my lord.
have crossed on the right side, left side, not on the right side. Enough, that's
Cross
it.
mark has to be given to the same who have he
Yeah.
put the right answer.
And every answer you check up, you have done it in that one.
But as for the instruction, serial number 9, it doesn't
Anyway,
say.
From when are you working?
My lord,
2000?
Uh,
When were you appointed?
I was appointed, just a second.
You are appearing for both R3 and 4?
Yes.
I have, my lord,
Respond number 3 and 4, both of them you are appearing?
no, only for respond number 3.
3. When was he appointed?
Just a second.
When was he appointed?
Just a second.
So, anything more?
No, my lord. But
I'll give it a quiet,
my lord.
More than 3 years before, my lord.
Only 3 years.
Before that. Maybe before even the case was filed,
I
yes?
think, my lord, in the year 2017, my lord, because since the result was declared on 18/11/2016.
The results were on?
On 18/11/2016. Oh, sorry, final selection list, it was declared on 2/1/2017.
2/1?
2017. 2
So
January,
immediately thereafter.
my lord.
ठीक है हर लर्नर काउंसिल सबका नाम ले लीजिएगा लर्नर काउंसिल फॉर द पार्टीज एट लिंक हियरिंग कंक्लूडेड registry to list this matter again on Monday
My lord,
for delivery of orders.
my lord, the date of appointment is given here, my lord. 9/29/8/2017.
Both respond number 3 and 4.
Yes, my lord.
29 Appointed on
29 August 2018. Sorry, 7th.
we are dismissing. Anything you want to say?
None. My lord, only one thing I would
Monday.
say.
Monday. Well, they'll pass the order on Monday.
My lord.
For 4 marks, he has already admitted in his affidavit, para 6. I have
Mr. Counsel.
got 4 marks. Thank you very much.
Yes, a very good fight.
Yes. All right.
Much obliged. Much obliged.
The original records are the
Lordship,